Good to go.
Okay, so this is the October 23rd meeting of the Common Council Committee on Operations and Ethics. Present are myself, Richard Conti as chair, committee members Tom Hoey, Sonia Frederick, and me. Okay, that makes a quorum, 3. I keep on forgetting to count myself. I know Joe was not able to be here tonight. He had the procedure, which he's just dealing with right now. But he is on board with this, and I don't know about Kelly.
He's coming in right now.
Excuse me?
He's coming in right now.
Oh, okay. And here's Councilmember Kimbrough. So we have 4 members of the committee here. Also present are Legislative Research Council, J.R. Pichardo, Deputy Clerk Kashana Burt, City Clerk Danielle Gillespie, and from Corp Counsel's office, Brett Williams. Purpose of tonight's meeting is to consider Local Law F of 2019, which is intended to adopt a comprehensive ethics local law for the city of Albany. So actually, I'll just quickly review. I mean, the actual proposal has been out there for a while. We've just never really had a chance to get to it. I will say that I've asked for comment from outside parties, and we've never really gotten any, or people have said it looks good, but I haven't, so I have never had any negative comment on it. I did have a discussion, I know, with Marissa and Dave Gallen before this local law was introduced back in 2019. We made some adjustments in accordance with that conversation. So that was the conversation I had. By way of background, it is basically patterned after a ethics local law that was adopted in Yonkers several years back, which was considered pretty groundbreaking at the time. So that's, the precedent in terms of it's kind of resembles the Yonkers local law. And in a sense, what it does, it's intended to, we do have, ethics laws on place right now. It's a combination of what's in state law, mainly in general municipal law, resolutions that have been adopted, et cetera, that, they're hard to find. The intention here is to bring together in one place to codify existing requirements, but also to establish some newer requirements, strength requirements as well. So it's not necessarily inconsistent with where we are right now, but it does expand and adds some additional provisions in there. The sponsor memo did include a comparison of current provisions that we currently operate under, comparison with what the county ethics law provides, and what this proposal is, so you can see some of the differences or changes. I'm just going to really run through some things quickly. It does strengthen some of the ethics provisions in terms of conflict of interest and transactions. It does strengthen some of the provisions related to the use of city property or office for, financial benefit. It includes a nepotism provision, which we don't have right now. It does deal a little bit more clearly with the issue of gifts with the intention of influencing an action. It does provide also like a 1-year ban on former employees appearing before a city agency, rather than the revolving door that you might have right now. It also, really hitting some of the newer areas. It also establishes an ethics commission, which we don't have right now, which would be comprised of 5 members appointed by the mayor, which are confirmed by a supermajority of the council. And they serve for fixed terms. They cannot be removed unless, except for cause, and then only also with the consent of the council, so that there's that extra safeguard built in there. The ethics committee would be able to issue advisory opinions. They would be able to hold hearings. They would have subpoena power. They would do investigations, etc. So it creates a strong ethics board with some authority. I think those are a lot of the provisions in there. Again, I'm just going through to see where the main differences were. I dealt with the conflict of interest, the gifts, the nepotism, which is new, confidential information, which would also include former employees as far as disclosure. Dealt with appearance before boards, the ethics board, etc. It also includes a whistleblower provision, which I don't believe exists in current law. Those are some of the main areas. I don't know if there are any questions or anything. And Tom?
Yeah, it's a pretty comprehensive document. I might have looked at a cover sheet. I never really dug into it. I worked 3 jobs, but it's my responsibility as a council member to go over this. But I wish I was retired at this point so I could spend a little bit more time studying these documents. But anyhow, I got some concerns. My first concern is when I got down to the makeup. Having all 5 members appointed by the mayor, I don't like it. I don't, even with the supermajority. And I'm not talking about this mayor, of course. I'm talking down the road. This is going to be a living document, and carrying on. People who are appointed are going to feel a certain loyalty to the person that appointed them, and it just doesn't feel right to me. I think we've done other boards or commissions where it's a couple from the council, a couple from here, there. I think we should try to look at something like that. The other thing is, you mentioned about political parties, that there'll be 2, one party and 2 another. I mean, I don't even think parties should be part of it. I mean, um, parties are formed outside the actual position. So I don't sit here. I'm Democrat Tom Hoey. I'm Councilman Tom Hoey, and I go along with the policies of the Democratic Party. But I'm a councilman first, party second. So that kind of bothered me when I saw that. There was a lot of stuff there, Richard. A lot of legalese, I call it. You know, that I don't understand. I guess that's the best way. And it's great when Judy or Mike's on, working with us. They explain it a little bit that laymen can understand it. And I don't mean, JR, I know you understand it too, and I could probably go to you, but as a peer is what I was talking about, as a council. So I'll shut up at that point. But that was, I think we need the ethics. But again, my concern, and again, I didn't understand. Another point that I caught me was, campaign contributions. I mean, I know what people got the last series of elections, and am I bothered that contractors or developers are making contributions to different people's campaigns? Is that something that could be brought in? I mean, we're really on stuff that I'd like to understand to make an informed vote, but that's where I'm at. Thank you.
So on the makeup of the ethics commission, something I struggled with trying to figure out how do you create an independent commission. And I think an earlier version had appointments outside the mayor, tried to do it through the judicial system or whatever. And typically they do, I think the appointments were not sure in terms of the county commission, which is, I don't know if that's really active right now, but I don't object to having a makeup that might be some council and some mayoral. At one time, an earlier version had a 7-member ethics board, which I think is too large. And it's hard, I'll tell you, it's also hard for us to find people to serve nowadays. And it's going to get harder and harder because I think, in terms of, we have more of a transient population in some ways, which, makes it more difficult to get people involved. And so the idea of having a supermajority was one way of putting a check on there. Another way is also extending the term out to a very long period, like maybe 10 years or whatever, which is the way judgeships are, to give it an aura of independence. But I don't have a problem in terms of, splitting them up. As far as political parties, that's kind of standard in ethics things, that you have, you don't want to give the appearance of one political party controlling it one way or the other. And so one way of doing that is you look at political affiliation to further provide some independence, or the appearance of independence of executive boards. So that's kind of a standard type thing. I don't have a problem, eliminating it.
Well, and let me just jump in on that one,
Yeah.
because, say in the city of Albany, we'll just say there's 10,000 people, and probably right now, 8,000 of those people are Democrats, probably 1,000 Republicans, and then the smaller parties. So what that does is give the people that are the 8,000 are going to get less representation on that board, if you know what I mean.
Yeah, but it's not supposed to be political representation. It's
Yeah,
supposed
that's
to be
true, too.
representation generally.
Okay.
But I don't have a problem.
Okay. Hey, but on the previous thing with the board, the makeup of the board, well, also on that, does it have to be city residents? That if it was, county, or, even outside that, that would be more outside of it being influenced by, if I'm a resident in the city of Albany and I find something against a powerful political figure and they're found innocent, now, am I a target? And that has to be something that would run through somebody's head.
Yeah, I don't remember if there was a city residency requirement in there. I don't recall there being one for the ethics board. And you're looking for people who, who have that background as well. So, but we can look at those issues. Sonia.
Thank you for providing the analysis. It's really helpful to compare state law to county law to the proposed changes. So I have a few points here, and I'm just going to keep looking down at my notes, just some questions and also recommended changes or some things I might have potential issues with. The first one is gifts. So I agree with the proposed language. However, in the county law, it says cannot accept gratuities over a nominal amount. We don't have that nominal amount portion in the proposed update, and I think we should add that, so we're not shooting ourselves in the foot for if we take a $1 or $2 on accident.
Okay.
Next one, nepotism. So just to confirm, this is not on state law or county law?
There is no provision that I'm aware of right now. And I looked at JR or Brett if they want to confirm or contradict. And
Nothing I'm aware of off the top of my head anyway.
The only nepotism, anti-nepotism law is on the federal level. That's it.
Okay. All right. For future employment, just looking here. So the county says high-ranking officers.
Yeah, could you, if you have a section that you can refer me to?
I'm actually looking at the analysis piece itself.
Okay.
So I'm on page 28 of the 31-page document. Let me know when you want me to.
Yeah, and of course, I'm not.
Want me to go?
Oh, actually, future, I got it here.
Okay. For this one, so the county says high-ranking officers and employees cannot appear for 1 year before county or permanently as to particular matters worked on while an officer and employee. And then the proposed change you have is officers or employees cannot appear for 1 year before the city. So don't know if we should attribute that to only high ranking? Or are you saying when we say officers and employees, we're talking about everyone under city jurisdiction?
There is a definition. I thought there was a definition here of officer. A city officer or employee is defined as any elected or appointed officer or employee of the city, whether paid or unpaid, and includes but is not limited to all members of any office, board, body, advisory board, etc.
Mhm.
And doesn't include judicial appointments. That particular section on future employment. I just had that marked. All right, so I think that would be 54-8, which says a city officer or employee or a former city officer or employee for a period of 1 year after the completion of his or her city service or employee shall not appear before any agency of the city except on his or own behalf or on behalf of the city.
Mhm. Okay.
So that, in other words, it's meant if employed by a department, you were involved in dealing with, and it's in the past, you may have had people, you know, in corporation counsel who deal with zoning and deal with specific zoning issues. And there are some examples of that, who left corp counsel, went to a private law firm and immediately began to practice in the area that they were practicing in when they were in the city employment. That could also apply to people in other departments, professionals, planning department, et cetera. The intent is, in effect, and I think the county language creates a permanent bar for matters that individual worked on.
Mhm.
That's a little bit strong. That is stronger than what I'm proposing. Mine would just be a 1 year prohibition before you can say, work for an outside agency on an area that you may have
Mhm.
worked on city employment.
Is there a reason why we
Oh,
don't
cool.
match the county?
The county is stronger. It provides a permanent, as I read it, a permanent bar.
So you just
Yeah.
couldn't
We can do that. I mean, if that's
a
what
topic that you
want.
worked on in the past?
Yeah, there's variations throughout the state on that one. I know with Senator Assembly employees, there's a 2-year prohibition.
Yep.
And if you ever work directly on it, no, it's just the 2-year prohibition. And then with the state, JCO prohibits, has a 2-year prohibition going before any board that you've ever practiced before or worked with. There's a 2-year prohibition. And if you worked on that particular case, there's a permanent bar.
Mhm.
There's variations of it.
Okay. I'm fine as is. I was just curious more
Okay.
so of the differences. Okay. So financial disclosure here. This one I'm struggling with because the proposed changes says requires information of all household members, not just spouse, and in some cases relatives. And then it says disclose exact amount, not categories, few exclusions from categories. This seems to be, at least from my read, more strict than the county law. Because we're attributing to everyone in the household. Plus, we're making you disclose exact amounts as opposed to categories. But am I understanding this correct?
Yeah, I'm just trying to go to. I'm trying to find the section where it deals with financial disclosure. Annual disclosure. Following city, this is in 54-20. City officers and employees holding the following duties or titles, et cetera, shall file an annual disclosure. The mayor, basically your elected officials, mayoral chief of staff, commissioners, department heads, bureau heads, principal deputies, all other officers and employees who exercise substantial discretionary authority designated by the mayor or ruled by the Essex Board. The clerk shall cause to be made. Extensions of, the Ethics Board shall promulgate an annual disclosure form that shall require the following information from the disclosing city officer or employees to be submitted. So it is one, the disclosing city officer or employee's name, et cetera, their employment position, the names of that disclosing city officer's employees or employee's spouse, relatives as defined, and household members, the name and address and telephone number of any outside employer, the disclosing city officer or employee, each close relative of the disclosing thing, each household. So at this point, it is just disclosing the names of people within the household and close relatives. Whether each outside employer or business is in response, whether the identification of real estate owned by the disclosing. Okay, so it does include, yeah, identification of real estate that might be held by the employee, the spouse, household members, or children, loans in excess of a certain threshold, et cetera. So it is broader than the current disclosure, which does apply to the individual and the spouse or domestic partner.
Yeah.
Did you have any clarification on that, or that?
More so because I don't know, I think the expansion towards other people in your household seems to be against what the county does and what the state does. So I'm questioning why we're adding that additional component there.
There can be a conflict within the household that it's not just what is held by the individual employee or the spouse, children or others within the household potentially. I think that was the rationale in terms of why that was there.
I think school boards require it too, right, JR?
Do they require, I'm sorry, Tom, do they require similar to what's in this proposal?
They require the spouse. I mean,
Yeah, the spouse is required. Spouse is required by the state.
Yeah. My point is, like, I understand that there could be a potential conflict of interest, but I just question why at the city level we're being more strict compared to our county and our state counterparts. Brett, do you have your hand up for this?
Yeah, I mean, I have a number of comments, so I can either, including about this particular issue, so I can either address this issue now, or I can go through and address all my comments at once later. Any preference?
Okay. Yeah.
Defer to Richard.
Unless, Sonia, you had other issues that you wanted to raise.
One more with the political activity section. And I think Tom might have alluded to this as well. Like, as it reads, it's proposed no candidate, current officer, or employee shall request that any persons who have received a financial benefit from the city in the last 12 months participate in any political campaign activity. So the way I interpret that, and I want to understand first and foremost, is, for example, if our neighbor works for DGS, they cannot do any form of lit drop for us. They cannot give you $10 for a campaign, et cetera, et cetera. And like,
No, I mean, that's your right, that person's right to individually participate in a campaign. It's meant, I think, more if to prevent or to deal with the potential that someone is receiving a campaign contribution in return for a favor that may have been done. It could be, whether it's an application or a zoning decision or things of that nature. But anything that would, you can't prohibit a city employee from freely participating in a campaign or the political process. And I don't think in that case, there would be any appearance that there was some conflict there or any kind of a favor being given one way or the other.
mhm. To that point, I mean, the county uses the word you cannot solicit. I almost like that better because it's making it more clear that you would be engaging or asking for money or something for like a favor. For me, that would be
I'm okay. I think that may have been an earlier version, and I think that's one of the things that in having some conversations earlier, that kind of fell through. But I think that was language in an earlier version, which I'm okay.
okay. All right.
Yeah.
All right. That's all I had for now.
Brett?
Thank you. And first, I'll just start with some things that I didn't have here on my sheet of notes that popped up during the course of the discussion. So first of all, Councilmember Hoey, if there's any, not just on this legislation, but if there's any legalese in any sort of legislation for the council and you want to discuss that or get any clarification on that, JR is a great resource for you, but I'm always available as well. To a separate point, I believe there is a residency requirement for members of the Board of Ethics. I think that's at section 5421B2.
Okay.
Just to circle back to that point. I guess otherwise I will just sort of start at the top and go down. So in section 54-3, subsection B, nothing substantive there, but candidate shall mean an individual who is on the ballot as a candidate for an federal, state, or local elective office. I think that should be for any federal, state, or local elective office. In subsection F, I have some slight concerns about the breadth of that language when it's talking about a customer or a client. $2,500, excuse me, is not a great deal of money, and I'm just thinking, if somebody has an Etsy shop online or they sell things at craft fairs, I just any person to whom a city officer or employee has supplied goods or services during the previous 12 months having in the aggregate a value greater than $2,500. I know I'm sort of reducing that to an absurdist situation, but it's just not a very large amount of money, and the language is pretty broad there.
Brett, can you explain that section, what it means in layman term, if you don't mind?
Yeah, so let me just give me 1 second to find the context where that comes up. This is just the definition section that I'm referring to right now, but if you give me 1 second, I can figure out where that comes into play later in the.
I mean, you can wait till later. I don't understand what it means that, this comes into effect if I make more than $2,500.
No, so.
Okay, I'll wait till you hit it.
Okay, that might be easier if we cover that one when we get a little further down into the law. But if I don't talk about that again, remind me. Yeah, in subsection K regarding household members, I think this is some of Councilmember Frederick's concerns. Household member or member of household shall mean any person with whom a city officer or employee lives in a single household unit. I know household has a specific meaning as far as, say, the IRS is concerned, but under this definition here, I think a household could be construed to include somebody's roommate or something like that. So then all of a sudden you're getting into ethical disclosures of your roommate's investments, or any loans that your roommate has. So we may want to more narrowly define what household and household members mean, which I think was a point Councilmember Frederick was already making. In subsection N, referring to outside employers or businesses, you know, on reading that further, I don't have any concerns there, I'm sorry. But in subsection R, there are two definitions in subsection R. There's relative and there's close relative. Relative means a spouse, domestic partner, child, stepchild, sibling, half-brother, half-sister, parent, stepfather, stepmother, mother-in-law, father-in-law, brother-in-law, sister-in-law, grandparent, grandchild, uncle, aunt, niece, nephew. So it's a pretty broad definition of what a relative means. A close relative is more narrow. It's just a spouse, domestic partner, child, stepchild, sibling, half-brother, half-sister, parent, stepfather, stepmother. But there will be situations later in the code, in the local law, where it's talking about gifts, for example. And it says, I think that no city employees or officers are not to receive gifts from anybody in excess of a certain amount, anybody who isn't a close relative. So I guess my concern there would be, you know, then grandma can't give you a gift in excess of $200 or $250. Again, I know it sounds like I'm reducing this to absurdist levels, but you know, we want to go by what the actual language of the law is. And we'll get to that specific section a little later. Just scrolling down, sorry, it is a long law. So the general ethics standards, Councilmember Hoey, I think this is what you were asking about. A city officer or employee shall not use his or her official position or office in a manner which he or she knows may result in a financial benefit for his or her customers or clients. That's paragraph 5 of subsection A. My concern there is, you know, if you have a little side business or something, like I said, you know, it's called an Etsy shop or a craft fair or something, and you know, you're selling a small amount, a relatively small amount of goods or services to somebody, then all of a sudden that person is, you're forbidden from selling to that person, or some sort of situation like that. I'm not explaining that terribly well, but again, it's just an issue of breadth that I'm trying to.
Brett, I've lost where we are in the document, and I apologize.
Sorry, yep, we are at
54-5.
54-5, yes, and I was specifically talking about subsection A, paragraph 5, but yes, 54-5.
Okay, thank you.
Yep.
But that's also, I mean, the qualifier that the city officer employee shall not use his or her official position or office in a manner.
Sure, yep, you know, but it just potentially makes a broader pool than maybe we want to look at as far as people who you'd be prohibited from dealing with. But I understand that that's it's sort of like a
it's not,
hypothetical.
I don't think it's a broad language. I think it kind of narrows in the intent there, but go ahead.
All right, skipping down quite a ways, looking at section 54-12. I think Councilmember Frederick addressed this one as well. I too share some concerns about the political activity language. I understand what the intent is, Councilmember Conti, but I think Councilmember Frederick did a pretty good job of explaining my own concerns there. Just the
So
way it's
where was-
worded.
Yeah, where was that again?
5412,
Okay.
and I'm looking at subsection A. So no candidate for any elected office of the city, and no city officer or employee shall knowingly request that any person participate in any political campaign activity. As you pointed out, there are certain protections under state and federal law, and certainly a person can volunteer their own time to work on a political campaign. So the way this law is written is that a candidate can't ask a city employee to help on a campaign. That may be I don't know, that could be unworkably broad. I'm not sure. I haven't.
I see a problem with that. I might ask my neighbor who happens to work for DGS, hey, can you help with my campaign? And that could be misconstrued. And, we see that all the time, in government right now. I mean, in the press right now, people they think they're saying one thing and the receiver is hearing something else. So I think you got to tighten that up.
Are you guys talking about subsection A?
Yeah.
Oh, okay, I see what you're.
My other concern with that one was we are a government town, the capital of Albany. We have a lot of state buildings here, a lot of state workers. So how do you even know, right? Like to some extent, like we all sort of have our foot in the game with the government. So there's just a lot of us.
And that is, the language here is limited to asking any city employee to help campaign for a city office. That narrows the potential minefield somewhat, I suppose. But again, maybe we want to conform that with the state or federal language. Skipping ahead again quite a bit to.
Well, can you stop on B, please?
Oh, you wanted subsection.
Well, the next item B of 5412. Can you talk about the $4,000, what that means and where that number came from?
Councilmember Conti might be best placed to talk about where the $4,000.
Yeah, that probably was just something we picked up out of the model that we use for Yonkers. But
okay, so can you explain what I'm having a hard time understanding exactly what it's saying? That a city employee can't give me more than 4,000, or can you explain that section if you don't mind?
I mean, at least as I read it, sitting here right now, it just says that public disclosure is required when a person has made campaign contributions to an officer or employee in excess of $4,000. So it's not saying you can't do that. It's just requiring public disclosure of those.
Right now, if you take more than $100 in a campaign contribution, you got to file that with the state. So are we kind of duplicating our efforts, or,
That's what it sounds like to me.
yeah, but the state disclosure is fixed at certain periods. Off cycle, it's like you have a mid-January, mid-July. If you're involved in a campaign, it's more frequent. This is disclosure at the point of something being made, an application or something of that nature, as opposed and in connection with whatever is being requested, as opposed to having to look it up separately.
well, could it be something that, we require a yearly disclosure of what campaign contributions you took in, anything over $100 to match what the state's doing?
Well, this is just for ethics because that's required by state law, what you're saying. But this is just that if somebody, a city officer or employee in the prior 12 months did it, it's just a note that it has to be disclosed. So it's more more kind of an internal disclosure. Well, internal, when I say internal, I mean like citywide, like internal citywide disclosure.
So this won't be, the general public won't see the disclosures?
No, the public will see the disclosure. It's just that it's in a different mechanism of within the city. It's just a little, it's still following the state guidelines and disclosure, but within the city, that if this is something that would be noted for the public.
But it's over, you know, the state says $100 and this says 4,000. So somebody can give me, you know, to me, anything, it's over $100, you know, you got skin in the game. You know, I'm a state officer, public officer, and anything over, I'm not allowed to touch anything over $75.
Right.
I mean, that's the law. And I understand that, but and again, we don't have to, I don't want to dwell on this because there's a lot of 39 pages. But it's just something, it kind of, I'd like that tightened up. I mean, and some kind of reporting mechanism, something like that. My fear is that somebody working for the city could take, you know, donations, and we're not going to know it from the state because, like you said, there's only certain filing periods. So I think I'd like to know more, less. I'd like to know what the state is asking. That's all. Thank you.
If there are any other questions, I was going to move down to section 5420 regarding annual disclosures. Under subsection A of that provision, the following city officers and employees holding the following job titles or descriptions shall be required to file a signed annual disclosure statement. I think something to this effect already exists to a certain degree, but if I'm not mistaken, this new legislation expands that slightly. And under this local law, commissioners, department, and bureau heads, as well as their principal deputies, would have to make these annual disclosures. So that is a pretty...
Yeah, so I'm going to back up here. I mean, this does repeal the existing one, which sets out a disclosure form.
Yeah.
And instead, the ethics board would design the form and what's required pursuant to what's here. I'm going to defer to Danielle, but in terms of, because I believe right now she determines who outside those specific people receive a disclosure form. And maybe you can comment in terms of where this might be different than the current requirement.
We put it on the parking lot and circle back, and I'll pull it up. I can tell you that we share it with the IDA, people who serve on boards and commissions, the council, and then the commissioners and department heads fill out the financial disclosure form. I don't know if that was the exact question that was asked that I was supposed to clarify, or if you want me to take what currently exists and compare and contrast it.
Yeah, no, it's really just who do you send it to in terms of the form? So you do send it to the
IDA, CRC, board, people on boards and commissions.
Planning board, BZA receives them. Commissioners, obviously, department heads, bureau heads. I mean, sometimes these are
common council members get them.
Yes.
In addition, so.
All city officers and employees who exercise substantial discretionary authority. Well, those would be designated by the mayor of the ethics board. But I'm just wondering how far different this then might be from what the current practice is.
I guess I was particularly wondering about principal department heads as well. Whether they're covered by the...
Yeah, so commissioners, department, and bureau heads, as well as their principal deputies.
Principal deputies, yeah.
So right now, Danielle, you would send it to a commissioner. And I mean, right now we have people who have the title of director, things of that nature. I'm not sure outside of a commissioner who might be in the department who might be getting it.
Commissioners, deputy commissioners, department heads. I send it, I cast a wide net. But I typically go through and see who got it in previous years and duplicate that effort.
All right. And does everyone who you submit to actually file a form or question whether they should?
I haven't had questions as to whether they should file a form. I don't always get the level of participation. I send out multiple emails and have to hunt and track people down. And then I point out that they're not in compliance.
Yeah.
And the state has a more broader definition. The state has, you know, all elected officials, appointed officials. And then the one term that I remember was policy making.
Policymakers.
And then if you made a certain income level, that's where it also got you to.
Yeah, there's the income level, which is, I think is mandatory. And then there's policymaker, which sometimes
There was always a debate of who was a
appointing
policymaker.
authority can designate who is a policymaker, for
Yeah.
example.
There was always a debate about that. I think in the state, they kind of just said all attorneys had to do it.
Yeah, they could be. I know in my office, when I worked in the assembly, my boss finally decided that he's the only policymaker as the elected official, and everybody who works for him doesn't make policy. But there was a point when I was having, so, there's a difference. The policymaker or the others file the long form. Everyone else, including, regardless of policymaker or income, files the short form,
Mhm.
which is similar to what we have for city employees.
Yeah, I was going to ask you about that because I know when we do it, it's very vague. It's like, do you make over?
Yeah, that's basically the same form that's used by the state for, the universal form, except for policymakers, elected officials, and people whose income is over a certain threshold.
Now, so we would move away from that form is what you kind of said before.
There are similarities. There might be some additional information in here. And, the ethics under this one, instead of having it in statute, the ethics board would promulgate the form. There's also a provision in here that information is not foilable or subject to public disclosure, would be redacted in terms of public disclosure of those forms because they are public disclosure. But there might be a little bit more information in terms of what is outlined here than in the current form. Real estate holdings are current. Loans in excess, we have loans now. There are certain exemptions. Interest and dividends is something that's listed in broad categories right now. Summary identification of any interest in the contract involving the city. I think to some extent that's kind of in the current one.
And that's actually state law too.
Yeah. Identification of any position held by the disclosing officer in the prior 5 years with a political party. That's going back further than what currently was required. Any relative of the disclosing officer or employee who is a city employee, that's beyond broader. Any identification of any customer or client of the employee, et cetera. So it is a little bit broader in terms of the information than you might get right now. And it's meant to, again, to, deal with persons who do have discretionary authority, who do make policy, even on certain boards and commissions like Planning Board, BZA, IDA, they have discretionary authority in some respect in terms of decisions that they make.
Do nonprofits come into play at all here?
I think it deals with agencies that might be regulated. If there was a contract. So it's possible if a nonprofit has a contract with a city agency, and you're, a board member of a nonprofit and sitting on, say, some board,
That you have to disclose.
that would just be disclosure, but not
Yeah.
a prohibition.
Okay.
And with regard to disclosure, particularly as it's discussed in subsection E, where it states that the annual disclosure statement shall be kept confidential to the maximum extent allowed by law. Certainly, I think it's a good thing to have that language in there, but I do want to caution against over-reliance on the FOIL exemptions. FOIL is pretty broad as far as what can be disclosed and what needs to be disclosed. And the presumption with FOIL is that items are disclosable. So that's just something to bear in mind. You know, I don't have any specific items that I'm going to say should or shouldn't be included in the disclosure forms, but you know, just it's worth bearing in mind that what people think should be confidential and what people expect to be confidential is not always what FOIL thinks is confidential, I guess, is the point I'm trying to make. Moving down to subsection G, where it lays out the information that has to be disclosed. There is a lot of information there, and most of that will be required to be disclosed under FOIL if a FOIL request is made.
Not all of it would have to be required to be disclosed under FOIL. A lot of it would be redacted, but it would be kept in-house.
Yeah, I mean,
Like home address, I know for a fact home address is redacted per FOIL for security and safety, that one. So I know that.
Yeah.
A lot of this would tend to be, it would be maintained internally.
yeah, certainly certain portions of it would be redacted under FOIL. I was going to talk specifically about paragraph 8. I think I already mentioned that to a certain degree. For just as an example, identification of all loans in excess of $1,000 made by the disclosing city officer or employee or that individual spouse, household members, or children, and investments over 5% of the stock, etc. You know, I mentioned already my concerns about household members, and then you're getting into children and things like that as well. I understand the reason that those items are in there, but especially with regard to the household members, I think that definition needs slightly narrower scope. And then paragraph 10, I also sort of made reference to before, identification of gifts in excess of $200 received by the disclosing city officer or employee, except for those gifts enumerated in section 54.6b.
I think those would be from relatives and
Yeah, again, so that was the difference between relatives and close relatives. So, you know, as I read that, any gift from an aunt or an uncle or a grandparent or something would have to be disclosed. Moving down again to section 54.29.
29.
Yep.
I always like to hear we're jumping ahead.
Yes, yeah. Yeah, pretty close to the bottom now.
Yeah, okay.
In subsection C1, it says, after a hearing, the ethics board shall impose one or more of the appropriate sanctions as follows. First point there is just a copy editing thing. It says impose a civil penalty in an amount not less than $250 nor more than $10,000, but the parenthetical
I see.
amount is that says $1,000, so I assume that should be changed to $10,000. I guess I have a slight concern that it doesn't give the ethics board a lot of flexibility in imposing sanctions or penalties. Subsection C says that the ethics board shall impose one or more appropriate sanctions as follows. So it has to do one of these four things as I read that. There's no option to impose less than $250. So, you know, the board wouldn't be able to impose a $0 or a $1 fine, you know, more of a symbolic thing. So it just ties the ethics board's hands somewhat. That may be the goal, but I'm just pointing out that that is the way this was written, that it doesn't provide for a lot of flexibility for the board. And when read in concert with section 54.35, again, skipping ahead quite a bit, this section talks about 5429C talks about penalties that can be imposed by the board itself, but then 5435 talks about how ethics violations shall be punished. Some of that language is similar, but some of it is kind of contradictory. That's one issue. Another issue is in subsection B of 5435, a criminal penalty as a class 1 offense of up to 1 year imprisonment or a fine of $1,000. I could be wrong here, but I'm not aware of anything in New York state law that's considered a class 1 offense. You have different tiers of misdemeanors and felonies, but I, to my knowledge, the phrase class 1 offense is not something that exists under New York law. And I'm happy to be corrected on that point if I'm wrong, but that's as far as I know. But my broader point, I guess, is that we have this entire section devoted to penalties, but then we also are talking about different penalties further up in section 5429. We may want to synthesize those. Yeah. It's a little duplicative.
That'd be fine.
And then I would have to look into this to provide a concrete opinion, but I question whether the ethics board itself can actually impose a criminal penalty on its own. You know, it can certainly refer things to the district attorney's office as it wishes for prosecution, or for the DA's office to look into things. But as I sit here right now, I question whether the ethics board can actually impose a criminal penalty on its own. And then the final point I think I wanted to make was, I think the way the law is written now, the ethics board can conduct an investigation. It can bring charges against a person, and it conducts the hearing itself. There's no separate hearing officer so far as I can tell. So that sort of gives rise to a situation where the ethics board would be investigator, prosecutor, and judge and jury all at the same time. And then it has the ability to impose these fines, and as it's written, potential criminal penalties. So I just have some concerns about that procedure and that setup as well. But I think that's it. I think that's all I have.
Brett, with the fines, where does that money go? Into the general fund?
I would think so. JR, correct me if I'm wrong, but I think it would go to the general fund. Yeah.
Go to the general fund. But if it's a city employee, it's really just a refund.
That's true.
It's really not a cash positive thing.
Is there any other questions, or obviously this is going to be going, we're going to make some revisions and adjustments, and we're not going to try and move this out tonight.
With 5435, Richard, and I'm digesting it now. So who would determine, are we going to put the wording in there that it would be referred to the DA to prosecute?
For what it's worth, Councilmember Hoey, that is the way it's worded in 5429, the other penalty provision, I think.
Yeah, we'll collapse the two. We'll have one penalty provision and see which makes sense.
In 29, though, there was no criminal. It was civil, right? I'm looking now. I don't see.
So in 29, the ethics board has the ability to refer anything it thinks may be criminal to the district attorney's office for prosecution. But then in 35, that's where the ethics board is empowered to impose a criminal penalty on its own. So yes, that is a difference between the two sections.
I didn't see it. That last sentence, I got it. Thank you.
Looks like Danielle has her hand up.
So, Danielle, Yes.
Can I ask a very quick question? So currently in section 54.5, it prescribes the form and it has everything all laid out. In this a piece of legislation, can we prescribe the form also and basically design it? Because that may be less confusing. I know it touches on the different things that you may or may not be required to disclose, but 54.5 does a real good job of laying it out and providing a visual.
Yeah, I mean, and the intent here was that this would give, and I'm not sure if other cities or localities that have a similar form, if they lay it out in their code, or if they have the discretion. This would provide that the ethics board would have the flexibility and discretion to design the form, and include what would be included. We can leave a form in code the way it is right now, and maybe make some adjustments to it. I actually, personally, when I'm filling out that form, that code, there are some questions there which I find a little bit confusing in terms of how you're supposed to report certain things like, interest or dividends, and then the addresses, and there's a microscopic section line that allows you to list stuff. And I'm not quite sure what they mean. So I find parts of the current form a little bit unclear. But that is the other option, is just we could put a form in code the way it is now.
We could create a form and make it conform to what is listed in the legislation.
Mm-hmm. I am noting that, as I see on the Facebook stream, and as Danielle has been alerting me, we don't have any public comment, but I do see some comments on the Facebook screen that let me just note, besides the ones that say hello, and since this is all public anyway, comment from Deborah Williams: there should be an explanation of exactly who is included in the definition of close relative. The expansion towards other people in the household, unfortunately, is needed, in my opinion. And I think that the city of Albany doing this raises the ethical bar. Jessica Wilcox: I believe the court system requires spouse. Deborah Williams: historically and currently there have been many problems with not including other close relatives. Jessica Wilcox: looks like state is looking for information on a spouse and unemancipated children. Rick LaJoy said, I do. I'm not sure what he meant. But that was just to note that there were some comments relative to what we're talking about on the Facebook page. So what I think I would like to do as far as moving forward with this is to work on, unless Tom, you have some.
Yeah, and again, this is going to be down the road, but I wanted to find out that it's on the radar, and I could be wrong. Like I said before, I work 3 jobs. So for my union, I got to take like a course on ethics, what I can do, what I can't. For the university, I got to do that. Do we have to do that for the city is my question.
We do, I think that's under state law, and we do have that annual, we watch the videos and then take a kind of a test or Q&A on it, or do certify that we've completed a course, but we do it virtually online.
Yeah, I forgot, and that's why I was just asking, because I think when we do get these changes in, we need to make sure that's updated, that people know what the guidelines are, I guess.
And I don't know if there's, to some extent, that if you're required to do something for a state job, can that satisfy, what the city requires, since essentially I believe it's all the same because it's all under state law.
Yeah, but we're changing
stuff,
right? We're tightening it up. So I'm just thinking for our employees, and myself included, I would rather make sure I'm understanding when this passes, what the requirements are is all I'm saying.
I
Okay,
believe the policies and procedures manual touch on ethics, and people have to sign off and acknowledge that they received the policies and procedures manual. And in most offices, they're supposed to post that the portion of the general municipal law that talks about what is allowed and what is prohibited. So we have it posted in the city clerk's office and in vital statistics, and I'm pretty sure it's throughout the city, and I've seen it posted in human resources as well.
okay. So what I'd like to do is work on some revisions. And if I could work with Brett and JR. And Brett, if you, either Brett or JR, if you have specific amendments that you can forward me or ideas, or, and then maybe we can work back and forth on some drafts, trading back and forth, and try to develop something that also, addresses some of what I hear from members as well. And we can try to tighten up. And I want to go back and look at Yonkers again, because this was, as I say, based on what they did, and things of that nature. And there is guidance from NICOM as well that we've looked at. So we'll then reschedule another meeting at a point where I think we're closer to having something that reflects some of the discussion from tonight. Does that work?
Yep.
Okay. Are there any other issues or items or business? If not,
Do you want to throw out,
Danielle?
do you want to throw out a tentative date for the follow-up meeting?
I was thinking about that, but then I didn't want to tie myself into something because I don't know how long it's going to take. But then, of course, the other argument is having a follow-up meeting gives you a deadline. Today is March 23rd. Do you want to, well, how do people feel? I mean, I'm hopefully, I don't want to say a week from now or 2 weeks. I know, Danielle, you have a better idea, because I know the planning committee has some dates on hold as well, which I think you have in your calendar.
Yeah, I'm looking at it now. I mean, if you did a week from today, you would be okay, because I don't see anything on for the 30th, but April 6th, there's a planning placeholder. I mean, the 13th.
Is the 13th okay?
The 13th looks like it's okay, yes. I don't see anything currently on for the 13th. So,
For what it's worth, I'm scheduled to be off on the 13th. I don't necessarily need to be at the meeting in person. I can submit my comments and have one of my colleagues at the meeting to discuss if need be, but I am off that day.
Oh, I know, you're essential though.
Well, I appreciate that.
Are you off for that whole week, or is that?
No, just the first part of that week. I think until Wednesday of that week. I'm here Thursday and Friday. So the 15th.
And I don't know if Thursday is good, Danielle. I know that the Violence Prevention Task Force meets every other Thursday. I don't know if that's one of theirs. The 15th.
I'm sorry.
Tentative
April
ACDA
15th?
meeting.
Yeah,
Okay. Well, let's say tentatively on the 13th, if you can put a hold on that. And then we'll see if we can turn that around enough to make that work. If not, we'll just put it off until the following week or whatever. So tentative, we won't notice it yet. I think we would have time to notice it, and we'll maybe have a better idea within the next week or so if we're within the ballpark.
Richard, will we be able to get the revised document, a couple of days before the meeting?
Yeah. No,
I'll read it, and I can call JR or call Brett and talk to them, so I'm not wasting the whole committee's time. When I don't know.
Yeah, I want to be able to get things out as soon as possible. So those drafts can also be refined with committee members as we move forward. et cetera. We'll be doing track changes, so that's the kind of documents that I assume. Any other questions or issues?
Yeah,
Kelly?
can you hear me?
Yep.
Yeah, I'm sorry. I have a meeting already scheduled on the 13th, which I actually missed my last one because we had our last operations committee meeting. So if we could adjust that, it would help. If not, I guess I could double
Is the
meet like I
12th?
did the last
Is
time.
the 12th open?
I don't see anything on the 12th.
Monday, April 12th?
That would work. That'd be great.
I don't see anything on Monday, April 12th.
I
All
would
right, so
have,
let's say tentatively Monday, April 12th.
same would go for me as for the 13th, but we
Okay,
can work that out.
okay.
Yeah.
If there's no further business, is there a motion
Yeah.
to adjourn? Oh, so, yes?
No, lastly, I would, earlier we were talking about, I think Ms. Frederick had some comments, and maybe even Mr. Hoy about why we're more restrictive or doing more stuff than the county or the state is with this stuff. I would argue that we're closer to this stuff, so there's a greater chance of these conflicts arising from where we sit versus a county legislator or a person that works for the state. Just a comment. So.
All right. Okay, motion to adjourn
Motion to adjourn.
by Mr. Hoey.
Second.
By Mr. Kimbrough. All in
Second.
favor, say aye.
Good night,
Aye.
everybody.
Adjourned.
Good night.
And
Good night.